Hi, I'm Susan Lipp, Editor-in-Chief of Trust and Estates. I'm here today with Mike Piershale, the President of Piershale Financial Group. And Mike, when a beneficiary inherits an IRA, what are the top concerns for advisors? What do they need to keep in mind?
Well, Susan, the first thing that we certainly will coach even to our own advisors that work in our own firm is to understand that there are at least 5 primary groups of beneficiaries, and the rules, the IRS rules for each group are different. So one of the most important things in titling a beneficiary is making sure first you understand the rules. Now, simple example, the first group that has the greatest flexibility of any other group is a surviving spouse. The only person that can take a deceased person's IRA and roll it over to their own IRA is a surviving spouse. Nobody else can do that. So it's a very powerful advantage. Also, for example, with a surviving spouse, if they're under 59 and a half and they need the income, they can leave the money in the deceased spouse's IRA and then take income without a 10% penalty, and then later when they're above 59 and a half, still do a rollover to their own IRA. All kinds of flexibility. We never worry about that beneficiary too much. The second group would be grandchildren or children. The kids cannot take a deceased parent's IRA and roll it over to their own IRA, but the IRS does allow them to set up another kind of an account called an inherited IRA, also called a stretch IRA, an eternal IRA, and so forth, a multi-generational IRA. And an inherited IRA is not an IRA, and the rules are different. The most important thing to understand is, number one, they got to be set up by retitled by September 30th of the year after the person passes away. First distribution must be taken by December 31st of the year after the person passes away. The other thing is to understand there is a distribution. Even if the let's say that beneficiary is 25 years old, they have a required minimum distribution, typically based on their life expectancy. We find more errors are made, by the way, with this beneficiary than any other. Reason being, especially they had this employee, they called it, I believe, the Employee Recovery Act of 2008 basically made the inherited IRA the default. So if the heirs, which are usually the kids, do nothing, it'll default to an inherited IRA. And you think, that's great, no problems worrying about that. But there is a problem, because if the kid is really clueless and is working with an IRA custodian that doesn't really contact them, which there are a number of them that will not, and they fail to do what I just described a moment ago and take the first distribution by December 31st of the year after the last parent passes away, then basically it's too late to do the inherited IRA, and then it would typically fall back to requiring them to take the money out over a 5-year period. So, the other thing that could happen is it would cause the kids, with some institutions, that you would have an inherited IRA set up, but they didn't take their required distribution, subjecting them to a 50% penalty because of not taking the required minimum distribution. The other major thing with the kids is often the kids find out they just inherited an IRA. They don't know there's an option available called an inherited IRA, and they just cash the whole thing out at once, which is a total disaster from a tax perspective. A third group is a charity, and the rules for a charity are simply this: when they get the IRA, it's tax-free. So frankly, we do have clients that leave money to their church. Often, typically it's a church, and one of the biggest bonehead mistakes they make is not making the retirement pre-tax money the money you're going to leave to the charity. And why is that? Because if the charity gets it, it's tax-free. But if you leave it to your kids, they got to pay taxes on it. So you're not hurting the charity at all, and you're leaving more of the after-tax money for your kids. But most of the time, we find when they're leaving money to a charity, rarely are they leaving it leaving the IRA money, which is, in our view, a bonehead mistake to not do that. Another group is a trust. And as of 2000, I believe it was 2004, I believe it's 35 states in the United States adopted what they call the Uniform Principal and Income Act. And here's the bottom line, Susan, without getting into all the, just the legal terminology, which I'm not an attorney anyway, and I don't practice law. But if you make a trust a beneficiary of an IRA, and that trust document is not worded properly, at least in the state I'm from, which is Illinois, it will become subject to the Illinois Uniform Principal and Income Act, which simply means that it would required distributions would get trapped in an irrevocable trust and subject to trust tax brackets, which basically means this. Normally, in order for you, if you're married filing a joint return, you don't go into the top tax bracket until your taxable income is over $388,000. So you got to make a lot of money to get into a 35% bracket. But if you're subject to trust tax brackets, you go into the 35% tax bracket after $11,650. So it's a big, can be a very expensive tax loss to be subject to have your beneficiaries become subject to trust tax brackets. So you have to just be careful if you're making a trust a beneficiary of an IRA. The last thing that I just wanted to comment on is per stirpes language with beneficiaries. Very rarely does anybody come into my office with per stirpes language on a beneficiary titling. And my simple example on this, let's say I have a dad who's a widower and he's got 3 adult children. They all have their own families. They're all married. They have all have the kids, 2 boys and a girl. Dad and his daughter out for a Sunday drive in a pickup truck and they get hit by the giant fly swatter. Dad had a $600,000 IRA and he loved all 3 of his kids the same, so he's going to leave $200,000 to each kid. Do you think Dad would have wanted his daughter's third, which is $200,000, to go to her 2 brothers or to go to her husband and her 5 kids? Well, I don't know what most dads would do. I know what I would do, and I do have kids. I'd want it to at least go to my grandkids and maybe the spouse if I liked them. Well, guess what? Without per stirpes language, it's going to go to the 2 brothers. And even if they want to do the right thing and give the money back to their deceased sister's family, which they, by the way, do not have to do, they could be subject to gift tax in doing so. So in other words, the way you avoid that kind of a situation is make sure you have per stirpes language in most states on your beneficiary titling of your IRA.
Okay, well, thank you, Mike, for coming down and explaining all that so clearly. For more information and also to read Mike's article on our website, go to wealthmanagement.com.